So good afternoon, ladies and gentlemen. It is my pleasure to pick up the baton from Gilles and from Elizabeth and to talk to you today about the risk management and custody arrangements under MiCAR. I know that Elizabeth has already started talking about the risks which MiCAR is set to address, and I am going to build on it. I'm going to basically map the risks, provide a concise overview of how MiCAR addresses the risks, and then zoom into the custody arrangements indeed. All right. So first of all, whenever we are talking about the risk management arrangements, I find it important to set the scene and to bring you mentally to, late 2019, when we heard of Facebook plans to launch Libra stablecoins and, to enter the world of finance by leveraging its power of a social media giant. And, I realized that when we heard it, many of us prefer to unhear it. We could not, unfortunately, but we do have to keep this image in mind when we talk about the risks MiCAR aims to address. So it is at that background development we had the impact assessment, and looking back at the impact assessment report of 2020, MiCAR's aim was to address 4 distinct categories of risks. So the first category of risks is consumer or investor protection risks. So here, and we already heard about it earlier, but just to sum up, this would include the risks that the consumers are buying unsuitable products based on exaggerated or misleading information. And I saw some photos there, very beautiful ones in Elizabeth's presentation, but it is indeed just underlying the fact that it is so easy for an uneducated consumer to actually make the wrong choice. Then the second one is the risk that consumers would incur losses resulting from fraudulent activities and deceptive practices. And for example, we know notorious fraudulent promises of high yield results. And again, it just looks so very much attractive to the uneducated consumer. And last but not least, the risks that consumers would incur losses due to the immaturity or failings of service providers, which could be the losses from such incidents as hackers attacks and software errors and data loss. In other words, all the losses which could come due to the operational risks which are not properly mitigated by the providers. Then we have the second category, and that is the market integrity risks. In this category of risks, we are talking about the risks of market manipulation by basically sending false signals about the supply and demand for crypto assets. And also, of course, lack of transparency of the price formation. We can also observe increased risk of market manipulation when we are talking about the trading platforms, when they are not subject to transparency requirements. So in such case, obviously, we do not have any guarantees that everyone gets equal access to information and a fair price. Crypto assets can, of course, also pose significant risks to financial integrity, as they may create new opportunities for money laundering, for terrorist financing, other illicit financing activities, but that has already been touched upon. So the third category is market fragmentation risks. So here we have the risks arising from all the beautiful variations in the implementation of MiFID II, and also the emergence of bespoke rules at national level for the crypto assets that do not qualify as financial instruments. So here we are looking at divergent national rules, which could potentially lead to substantial regulatory fragmentation and distort competition in the single market. Now, coming from the Netherlands, well, here we did not have any rules, but, I know that there are member states, of course, who are much more further in that than us here. And basically, the divergent national rules could also create considerable complexity and legal uncertainty to those providers who were looking at extending operations on a cross-border basis. So then they would face the requirement to seek licensing from the supervisory authorities of different member states, and that potentially could create obstacles. So that is the third category. And market fragmentation could also undermine basically the first two, the investor and consumer protection and market integrity in the EU, in the absence of the single playbook. You know, when you do not have the single playbook, the level of investor protection and the measures against market abuse, again, would be different, whether or not we would try our best. And the last category is financial stability and monetary policy risks. So again, remember the Libra story? This category of risks basically mainly arises from the stable coins, or in MiCAR language, asset referenced and e-money tokens, that have the potential to gain a substantial global footprint, so global stable coins. If a stablecoin arrangement becomes systematically important, it would raise challenges to financial stability and to monetary policy transmissions. So these are all the risks. And now the question arises, of course, how does MiCAR manage all these risks? So let's start from the most straightforward one, the market fragmentation risk, and for that I did not create a slide. So here the risks of market fragmentations are being managed basically by the mere fact that markets in crypto assets provides a comprehensive regulatory regime for all member states and is basically replacing the national frameworks which were put in place in certain member states. And by introducing the EU passporting mechanism, MiCAR basically eliminates the whole concern about the barriers for cross-border operators as well. Now, let's look into consumer or investor protection risks. So here we basically introduced a number of requirements. First and foremost is the obligation to inform prospective purchasers of crypto assets of the characteristics, functions, and risks of the crypto assets that they intend to purchase. So here we are talking about the requirement to draw up a crypto asset white paper and basically make sure that it contains quite a lot of information, which is important and necessary for the prospective purchasers to make a well-informed decision. And we are talking here about not only the general information on the issuer, but also on the offer and on the rights and obligations attached to the crypto assets, and also underlying technology, and last but not least, all the related risks. Now, the white papers that basically, when we look at it, they do resemble prospectus for crypto assets, right? And the thing here is we have to make sure that they come as comprehensive as possible. One very important point that they need to include here is also the fact how the climate-related impact is measured and how it is being addressed, and also to see, how much of adverse environmental and climate-related impact this specific asset is creating. Then, of course, very important measure introduced in MiCAR is the right of redemption, but also MiCAR grants retail holders the right to withdraw. So we have one very important right is the right to withdraw from the purchase of a token if it is bought on the primary market within 14 days, but also very importantly, the tokens have the right to redeem their tokens at any time, and they are also obliged to hold the reserve requirements to issuers would be able to redeem, and they will not run into any leaks or we have a specific to the authorized crypto asset service providers. They become, already mentioned, a set of rules which are applicable to all authorized service providers, basically obligation to act honestly, making sure that they are acting in the best interest of their clients. But there are also specific ones related to the different types of crypto service asset providers. For example, if you are talking about the exchange services, an obligation to draw up a non-discriminatory policy. If we are talking about the asset service providers providing advice and portfolio management, then the obligation to provide assessment whether those are suitable for their clients, and etc. We are going to talk about it a bit more in details when I'm going to switch to talking about the custodians. Now, the next category, the market integrity risks. So here we have basically all the important mechanisms which are introduced with regard to the asset reference and e-money tokens here. So we have more stringent requirements put on the issuers of these two types, which are basically both are stable coins, the permanent right of redemption, strict conditions on the issuance of the e-money tokens as well, introduction of various requirements on the operational, organizational, and prudential ones applicable to the crypto asset service providers. And also a requirement, which is very important for the second part of my presentation, is a requirement for all crypto service asset providers to be legal persons with a registered place and effective management in the European Union member state, plus at least one of the directors being the resident. It does have a very interesting effect, and I'm going to talk about it a little bit later. And last but not least, how do we address the last category, financial stability and monetary policy risks? Now, here we are talking about the fact that we do have, of course, again, stringent requirements. That's a one and very important one. As issuers of asset reference tokens, they are subject to their own fund requirements, and there is a whole calculation as a percentage of the reserve assets that back the value of those tokens. So we do want to make sure that there is sufficient backup. You have also more stringent requirements with regard to capital, interoperability, establishment of a liquidity management policy, and the ability of the competent authorities to either not authorize or to withdraw the authorization if you could see that the specific token poses the serious threat to the stability and monetary policy. So these are like a very brief overview of how throughout MiCAR we see how the different risks are being addressed and what kind of measures have been introduced. And now I would really like to move to the custody arrangements. So providers of custody and administration of crypto assets on behalf of clients, that basically falls under the category of crypto asset service providers and is defined as safekeeping or controlling on behalf of clients of crypto assets or of the means of access to such crypto assets where applicable in the form of private cryptographic keys. Now, what we see is that this definition really very closely resembles the one in Anti-Money Laundering Directive. Though we were looking at it in the academic world, it's like, now it also says controlling. Does it make it wider or not? And this is something that we are currently considering. And then we are basically looking at the fact that for these kind of providers, you would have two different baskets of obligations. You would have the obligations which are applicable for all crypto service providers, and you would have specific obligations which are only applicable to custodians. Let's look at that. First of all, of course, the authorization requirement, and that is very important. The power to authorize and supervise such service providers, that power lies with the national competent authorities, where that entity has its registered office. So basically, where an authorization by the national authorities is granted, it should indicate the services for which the authority has been granted, and it should be valid for the entire European Union. It is important to note here that a third country firm then can only provide crypto asset services on reverse solicitation basis. So here you would see that it is possible for the parties established in the European Union to receive such services from a third country firm on their own initiative, but it wouldn't be possible for a third country firm to solicit clients or promote or advertise its services or activities on the territory of the European Union. And this is something that made quite a lot of service providers outside of the European Union and, aiming to offer their services, of course, very new. So what do we have here with regard to the obligations for all crypto service asset providers? Now, first of all, we have very strong organizational requirements. So the governance arrangements. We have strong requirements with regard to the members of the management body, that they should be fit and proper and have all the necessary knowledge, skills, and expertise to take all the necessary steps in order to perform its functions, but also in order to create a solid business continuity plan. They should have sound internal control and risk assessment mechanisms, and also adequate systems and procedures to ensure the integrity and confidentiality of the information which is being received. We also see that crypto asset service providers should have appropriate arrangements to keep the record of all the transactions, and basically making sure that there are systems in place to detect potential market abuse committed by its clients. And we also see, of course, various prudential requirements, an obligation to act honestly, fairly, and professionally in the best interests of clients, the requirement to set up complaint handling procedures, and to plan and carry out an orderly wind down when necessary. So we do have all these requirements applicable to all providers. Now, basically, we do need to switch to the custodians. So we do have specific obligations for custodians here. And it is important to, first and foremost, of course, realize that the authorization requirements by definition, of course, are applicable to them. But we also have the new requirements, such as, for example, and the one like me being a lawyer in my previous life, is the requirement to should have certain mandatory provisions and should establish and implement a custody policy, and also basically specify the nature of the services which are being provided to the clients, the holding of the crypto assets, how these assets can be accessed, and basically, what kind of relationship and all the background information required for the clients to assess whether or not, this is the service provider they would like to choose. Quite a lot is being put in this kind of agreement, and it is very interesting for me as a business lawyer to see what kind of beautiful variations of that might arise in the future. Then what else do we have? We do have the liability for the loss of any crypto assets or of the means of access to the crypto assets as a result of an incident that is attributable to the custodian. The liability is there, and what is very important, it is capped at the market value of the crypto asset that was lost at the time the loss occurred. So currently, it is no longer possible for the crypto asset providers to cap it at a lower rate. Then we have the requirement to segregate holdings of crypto assets on behalf of the clients from their own holdings of a custodian. And this is a requirement which kind of is mentioned double, right? We do have the requirement of safekeeping under the general obligations, but then we have a more specific one under the obligations for custodians, where again, we are talking about safekeeping and segregations of the holdings of clients from the ones of their own. And it was already mentioned when we are talking about the agreement, we said the agreement also needs to include the custody policy. And the custody policy needs to basically include all the internal rules and procedures which the custodian has in place to ensure the safekeeping and the control of the assets, or also the means of access to these assets. So basically, we see here that the custodians currently have and the prudential requirements and have the requirements to the governance, and have very strict requirements of what kind of policies need to be there, and also a requirement to sign an agreement with its clients, which actually has to include all the important information. Now, these are the obligations for the custodians in a nutshell. We do have one, which I also mentioned on this slide, which is very important to note, is that the custodians are only allowed to use authorized service providers. So suppose that the custodian would like to make use of sub-custody and would like to make use of other service providers, and it would no longer be possible to use those providers which are outside of the European Union. Then they would be limited to only authorized service providers here. And then we do have additional requirements regarding the custody of the reserve assets. And these are the requirements which we have from the whole discussion on stable coins, right, on the asset reference tokens and the e-money tokens, the requirement to keep the reserve assets, and those reserves have to be with the custodians who are not the issuer. And here we have basically additional requirements. So for example, we have to make sure that the concentrations of the custodians of reserve assets are avoided. So there should be constraints in place which would prevent the issuer from investing more than a certain percentage of reserve assets with one single entity, and also holding in custody more than a certain percentage of crypto assets with one custodians. Then we also have a requirement that basically the issuers of asset reference tokens, they should have in place custody policy for each pool of the reserve assets. So different issuers would now have to, the issuers have to create different pools depending on the nature of the assets. And last but not least, different issuers of asset reference tokens that have issued the same token should maintain a single custody policy. So that is also important to mention. Now, what is interesting in the custody arrangements with regard to the custody of reserve assets, we have specific rules on, where that custody needs to be and with what kind of entities. So depending on the nature of the reserve assets, like if we are talking about the financial instruments, and those need to be placed with an appropriately regulated investment firm. If we're talking about crypto assets other than financial instruments, those need to be placed in custody with an authorized service provider under MiCAR, and for all other assets with the credit institutions. So it does sound very logical to us, but there is one thing what is not really clear is, but what if the asset reference token backed by commodities? So it looks like then the commodities should also be in custody with a credit institution in the absence of further clarification, and that would normally not be the case. So it is also interesting to see what kind of rules should apply if the asset reference token backed by the commodities, be it gold or oil or whatever other type of commodity is out there. So these are, in a nutshell, the custody arrangements from my side. And I would like to thank you for listening. I'm very happy to answer any questions you might have.